morning and good afternoon to In-House Counsel from all across North America. Welcome to In-House Connect. My name is Shai Mahani and I'm the CEO and co-founder of In-House Connect, and I'm thrilled to have you here with us today. Thank you for spending your lunch or your breakfast time with us, and special thanks to today's sponsor, Vedder Price, and our wonderful presenter, Dan Shulman, for putting together this fantastic presentation on NDAs, a topic that apparently is very near and dear to many in-house counsel's hearts. I never imagined that this presentation would be so popular. It's our most popular presentation thus far. So thank you so much, Dan, for taking the time to put this presentation together and for giving this presentation. For those of you who are here for the first time, let me give you a quick bit of background about In-House Connect. In-House Connect started 11 years ago as a New York City-based meetup group for in-house counsel. Every month, In-House Connect would organize free CLE events or classes hosted by different law firms, which were followed by cocktail networking receptions. And every 6 months, we would organize fun and festive networking mixers. Over the years, we've helped thousands of in-house counsel connect with peers and outside counsel alike. The group was humming along, and then, of course, COVID hit. We couldn't meet in person, so we went online, which has been a fantastic transition. We've been able to attract a much larger audience of in-house counsel from coast to coast and across North America. Shout out Canada. If you're from Canada, let us know in the chat. We've been able to facilitate way more networking and relationship building, and we've been able to feature high caliber speakers like the one we have today, who I'm going to introduce in just a few moments. It's time for today's event, NDAs for in-house counsel. Today's presenter is Dan Shulman. Dan is a shareholder at Vedder Price and a member of the firm's intellectual property group in the Chicago office. Dan's practice focuses on all aspects of intellectual property acquisition, monetization, and enforcement, including complex patent litigation, trademark litigation, copyright litigation, trade secret litigation, and all aspects of patent and trademark prosecution and portfolio management. Dan also focuses on complex commercial matters, advertising disputes before courts, and the National Advertising Division of the Better Business Bureau, product liability, antitrust matters, and enforcement of restrictive covenants. He has experience managing all aspects of domestic patent prosecution and litigation relating to consumer packaged goods, electronic exchanges, insurance industry, telecommunications, financial products, mechanical and electrical devices, and prosecuting patent applications before the USPTO. He also advises clients on intellectual property transactions, including technology development agreements, confidentiality and joint development agreements, licensing, and mergers and acquisition. Dan brings over 12 years experience as Chief IP Counsel for a multi-billion-dollar companies holding thousands of worldwide patents and trademarks. While in-house, Dan developed licensing strategies for the licensing in and out of next-generation technologies. He managed due diligence processes for the acquisition and disposition of patents, and advised on litigation and defensive strategy relating to litigations. He managed an entire global patent and trademark portfolio for the North American operations of a consumer products company, having over $12 billion in annual revenue, while developing strategic technology areas to drive company innovation, directing innovation and patent filing, and protecting their global patent portfolio through strategic interaction with foreign patent counsel. As an in-house attorney, Dan developed keen insight into the challenges businesses face, what constitutes quality service from outside counsel, and how to meet or exceed a client's budget expectations. We are extremely fortunate to have Dan presenting here to us today. And with that, I will stop talking and I will turn things over to Dan.
Well, thank you, Shay. And I don't know if I've ever actually heard my bio read to me, and I used to think I was humble, and now I'm not so sure. Thank you very much for enabling me to come, for coming to the event, and for giving me an opportunity to put on my suit post-COVID and find out that it still fits. Let's talk a little bit about non-disclosure agreements and hopefully reset some of the understandings that came out of that poll. All right, so the basic thing. Why do we have non-disclosure agreements and why are they necessary? It's really simple, right? And you think about it, when do you want a non-disclosure agreement? When you disclose your company's confidential information, designs, business plans, technologies, you all know what that confidential information is. When do you not want a non-disclosure agreement? when you're receiving another party's confidential information, right? Reason why you don't want it, maybe multiple reasons. One, you don't want the obligation. You don't want to have to protect somebody else's confidential information. But there are other reasons. For example, you might not want to know information that will block your punt, where somebody might come along and say, hey, you got that from us, even though you were already working on it. Even if you weren't already working on it and can't demonstrate that you were working on it, it was part of your development plan and you would have come to it eventually. And now all of a sudden you've got a confidentiality agreement that might block what you wanted to do. So let's think about this in more detail, right? So there are two types of non-disclosure agreements, obviously. You all know that. The mutual, where both parties keep each other's information confidential, and the one-way, where only one party is the discloser. Here's what I want you to think about, the rules for the NDAs. That a one-way NDA where you are the discloser is always okay, and this should be the default. A mutual NDA, or worse, a one-way NDA in which you are the recipient, should always require legal approval. And I say that knowing full well that only about 17% of you had as your standard NDA the one-way NDA, and most of you had as your standard NDA the mutual NDA. So let's talk about why that might be problematic. Okay, so why is the wrong one so risky? Well, the risks are if you're a recipient of another's confidential information, right? Most NDAs prohibit disclosure and use of the information, except for the benefit of a business relationship with the discloser. So, if you enter into an agreement with somebody who gives you confidential information, and you don't then enter into a business relationship with that party, you might end up having your development blocked. You might end up having other uses of that confidential information or your own confidential information blocked. An NDA where you receive somebody's confidential information, again, even if you don't know it yet, but would have inevitably come upon it in your own product development, your own research, your own company activities, could prevent you from using that information. It could prevent you from using information you already have or would have discovered on your own. Now, I know confidentiality agreements always have the exceptions for independently developed confidential information and so forth, but it's very hard to prove. And even if you can prove it, it's a fact issue. And you might end up going in front of a jury or in front of a judge trying to prove what you knew, what you didn't know. And guess what? You might be the big company, the Goliath versus the David in that transaction, in that litigation. And that's a bad situation for you to be in. The other problem with non-disclosure agreements, and I know people know this, NDAs do not cover development work. They are backward-looking and apply only to information that already exists. So a confidentiality agreement will only protect stuff that's in existence. I know, and if I asked this poll question, I'm sure I'd get plenty of yeses. How many of you have clients that have entered into non-disclosure agreements for a joint development project and then went directly into development? I'm sure it happens all the time. It's the thing that makes in-house lawyers pull their hair out. Let me give you a couple of examples of some dangers of some non-disclosure agreements. I had a client that came to me with a mutual non-disclosure agreement. They were looking for pricing on some product that they were going to use in their business. And they wanted to solicit pricing from a supplier, and the supplier handed them a mutual NDA, and they came to me and said, is this okay? And I said to them, well, what confidential information are you getting from the other side? They said, well, their pricing. I said, fine. Well, what are you planning to do with that confidential information? They said, well, we want to use that to go around and shop it around for other people's pricing. I said, well, you see, that's exactly what they don't want you to do. That's why it's a mutual non-disclosure agreement. It had not occurred to the procurement people that that was the sort of thing that they couldn't do. And in fact, we're signing mutual NDAs left and right and then shopping around information. not understanding what it means to have a confidentiality clause, that even if they didn't disclose it directly, that the use of that information could be a violation. I'll give you another example. And this happens especially in the consumer packaged goods world. You have a relatively large customer, a big CPG firm, could be somebody like Coca-Cola or Starbucks or McDonald's or Clorox or P&G, just to pick out and not picking on any of them. And they want their suppliers to come to them and share information about some new product that they want to launch. And what these companies frequently do is they'll have basically innovation fairs. Well, they'll bring in all of their suppliers to pitch on their capabilities and how they would handle this new product launch. And what typically happens is they will want you to sign at a minimum a mutual NDA. And as you sit there disclosing all of your confidential information, they give you feedback about the products that you're proposing, how to make them a little bit better, how to make them work for what that company wants to do. And all of a sudden now, you've got confidential information from somebody else about things that you hadn't thought of but probably would have, routine product improvements that you would have implemented. And when your company doesn't get chosen for that work, you're blocked out. You can't go to a different customer with that same idea, even though you would have come with those very same improvements, very same innovations that were shared with you from the big customer. And you've blocked your creativity. It's really important that you not get, as I say, pregnant with somebody else's confidential information if you don't want it and don't need it. When you're doing a mutual non-disclosure agreement, the question you always have to ask your business is, what do you need from the other side that's confidential, and how are you going to use it? And very often the best thing to do, if you can't get by with a one-way non-disclosure agreement, is when you have a mutual non-disclosure agreement, is to specifically identify what you're going to be getting from the other side, and make sure that the people who are sitting in the meetings and exchanging information know when to put a stop to the meeting, when information is crossing the desk or crossing the table that they don't want. Say, hold on, we don't want that information, we don't need it, we're just here to pitch you. You can tell us whether you like it or not, but don't give us any feedback, we don't want it. I have seen so many times in my career relationships gone south, gone sour, and blocking future development because of the way mutual non-disclosure agreements are used. All right, so how do we do it right? One, overall goal, ensure you don't receive confidential information you do not want or need. Ensure that you can transition to development without being exposed to loss of intellectual property rights, and we'll get into that in just a little bit more detail. And then ensure if you do engage in development, you account for the fact that most development fails to result in a commercializable product. So let's talk about a hypothetical, because this is the kind of hypothetical where the use of the non-disclosure agreement incorrectly really does put your company at risk. And we're typically talking about a non-disclosure agreement that is part of, usually the first step, but all too often maybe the only step, in a development or a joint development project with another party. So let's assume client, being you, your clients, a worldwide manufacturer and seller of a broad spectrum of personal hygiene products, so soaps, shampoos, creams, lotions, etc. And you believe that having a consistent and distinctive color and scent across all of your personal hygiene brands will be a positive brand identifier and a powerful differentiator over private label products. You have expertise in manufacturing those hygiene products, but you don't really have the chemical knowledge of scents and pigments. So, you have a potential partner who's a worldwide manufacturer of chemical scents and pigments, and they have an array of product offerings. But they also have the capability of doing new product development. So they have the experience you need in terms of manufacturing and testing chemical scents and pigments, but they don't really have the know-how in integrating those ingredients into the manufacture of personal hygiene products like yours. So what do we have? We have two companies that need to work together for potentially a win-win. The client and the company are a perfect match with complementary technologies if the development's successful. And there are alternatives to company the client can pursue a deal with, but your client has selected the company as a starting point. So now the client comes to you with a mutual non-disclosure agreement proposed by the company, and they're ready to dive in. Okay, so how do we make this work? Right. What I like to propose, and I've used this very successfully over my career, is what I call a development and evaluation agreement. Now, there are some very, very specific clauses to this development and evaluation agreement that account for the goals that I talked about. Protecting the intellectual property, not getting confidential information when you don't want it, ensuring that when you get into development, the IP ownership clauses are tailored to the development, and also making sure that the IP ownership and the confidentiality is accounted for even if the development fails. I know most of you have seen or heard the comment that somewhere around 75% of new development fails. That happens whether or not it's your internal development or a joint development. And a development agreement that says we're all going to jointly develop this, and at the end of the day, here's how we're going to handle the intellectual property, usually fails because at the end of the day in the joint development agreement is a commercialized product. That frequently, way more often than not, doesn't happen. And so when you have a commercialized product, it's almost always going to be a win-win. The parties will figure out how to do it. But who owns the intellectual property when it's only partially in process, when it's only half developed, when the development breaks apart, as it almost always does? A development agreement that doesn't account for the failure of the development isn't going to do its job as the development agreement. Okay. So, from a non-disclosure agreement confidentiality standpoint, this is really important. We typically would have two development pathways when we enter into an agreement with a party. The one would say, tell me what you have that is essentially off the shelf, your non-confidential solutions. This is to prevent the parties from sitting in a room together, being told something confidential that they don't want and don't need, that prevents them from going to another party if the deal doesn't work. So tell me what you've got. Tell me what you have that I can just issue a purchase order and take delivery of. It might be proprietary, it could be patented, but I don't want anything at this initial stage that's confidential. So in path one, you evaluate current technology. The parties consider commercially available, non-confidential company technologies. And if that works, then great. You buy it and you integrate it. All right? And then we talk about, by the way, when we talk about the company background intellectual property, and this is part of any development agreement, where you license each other background intellectual property in order to do the development, but for no other reasons, the existing solutions are going to be included in that background intellectual property. And the company represents and warrants that existing solutions are not company confidential information. So when you're sitting across from a party to do a potential joint development, you can use this agreement in lieu of a one-way or a mutual non-disclosure agreement and go ahead and get the process started, because it ensures you're not going to advance to getting confidential information unless and until you need it. So what happens when there are no existing solutions and those don't work? Well, now you go into the development pathways. And if there are no existing solutions that are satisfactory, then the development work goes into effect using a statement of work that outlines the milestones and responsibilities in much the way that all of you understand statements of work with any kind of consulting or project or professional services agreement. But now you're going to develop new technology. And the point is that no new development starts until the existing pathways have been exhausted and the parties execute a statement of work, because now you know you're going into the development of intellectual property stage. So, as an example, right, in any development agreement, you might have the innovation stages, but this is really important. It's important to outline what the innovation stages are, because as we see, you might have different interests and the other party might have different interests in maintaining confidentiality in intellectual property, depending upon what stage of the innovation and what stage of the development you're in. So as an example, stage one might be just ideation. You might move to feasibility, which is very broad proof of concept. Then you get into development, trying to really scale it up, ensure that you can do it for the right price, and eventually get to documenting a commercialized agreement. There are individual stages that you'd need to go through. And at each individual stage, you might have a very different interest in protecting intellectual property than you would at another stage. You don't just assign ownership of intellectual property as if the development will be successful. So let's talk about it in that term. So first of all, and by the way, for those of you who reach out to me individually, I can make this agreement form that I've developed available to you, and happy to walk you through it in more detail. So what's the important thing? I think one of the important things is that ownership of the intellectual property should be by field, not by inventorship. Why? When you do intellectual property by inventorship and you have a joint inventorship in any joint development, the parties are going to co-own the intellectual property with the right to exploit it with others without any restrictions. That presupposes an outcome that you may not want, right? It is much better in a joint development agreement where each party has their own potential development, their own potential fields of use, their own potential needs, that the ownership is allocated by field and not by inventorship. The other thing that's important is to allocate your IP ownership by stages. So if you terminate, let's say, in the feasibility stage, you've gone through ideation, but you're not sure that any development will be successful. You don't know that it will work as the right cost. In that case, you might want a right of first refusal of a license if your partner is able to commercialize it. You didn't think it could be done. The partner says it can be done. They've used some of your input in order to get there. If they're able to get there, and if they're able to get there on terms that work for you, you might want a right of first refusal. And that might be okay with the partner because they will get a commercialization partner. Now let's say that you've demonstrated feasibility, but now you haven't quite gotten it through development. The development fails. Maybe because the party's efforts didn't work, maybe the cost or manufacturability can't be solved adequately. In that case, what you're saying is, I'm really not as interested in this as I might have been. And each party might have that very same view, in which case each party might get a non-exclusive license to the other's developed IP. You could have had it if you wanted it. You didn't think it was important. You didn't think it could be done. It's no longer strategic. So you might have a very different interest in the intellectual property than you did, say, if you terminated during stage 2. And then after stage 4, if you're the client, what you want to make sure is that you have a license to the intellectual property that's not exclusive so that you can guarantee a second source of supply. That's part of the commercialization stage. So there were some questions about residual clauses and IP clauses in the non-disclosure agreement. So let me just address that. I think those are great. I think it is wonderful if you are able to put an IP clause in your non-disclosure agreement, if your non-disclosure agreement is a one-way non-disclosure agreement. And in fact, I've had clients that have used the one-way non-disclosure agreement that says everything developed under the non-disclosure agreement is owned by the disclosure. The problem is that if it's very hard to get somebody to agree to that, and that may end up spoiling the deal, especially if you're going to go forward with any kind of development. That's sort of a final stage decision. But if you have the leverage to just give a one-way non-disclosure agreement with an IP clause, that's a great way to do it. Residual clauses can be similarly difficult. What frequently happens is you want the non-disclosure agreement to be relatively painless, so you can get on to the next stage of the discussions. Always say and I'm sure you all know this, a non-disclosure agreement is to talk about a project. A project agreement is to do the project. And sometimes you just need that non-disclosure agreement to get talking about the project, and the residuals clause is going to slow things down. And if you are careful about, again, making sure that you're not receiving confidential information that you don't want, and making sure that if you enter into an NDA, you have a very clear view, and you always ask your client, what are you receiving from the other side that's confidential? You can maybe draft around that without getting mired in residual clauses. I know there was a question to get into one of these sections in more detail, and I will get into that. Jeff, that's a great question. So the question was, do you typically see a perpetual confidential obligation term for trade secrets? Yes, very frequently. Terms in a confidentiality agreement, things to keep in mind. There are really two varieties. There are two terms in the confidentiality agreement. Terms in terms of term of the agreement. One is the term of the agreement itself, which just specifies over what time period are the parties going to exchange information. That can be as short as a month. That could be as short as a year. That can be as long as 5 years. The other term is how long is the confidential information going to be kept confidential, and very frequently an agreement will say something like the information will be kept confidential for a period of 5 years after disclosure, 3 years after disclosure, up to 2 or 3 years after the term of the agreement is over, but trade secrets will be confidential indefinitely. If it's a mutual NDA, most parties don't argue about that because it benefits both. If it's a one-way NDA, you might get a party that says, well, how do I know what's a trade secret? You might get into some of the difficult discussions about, well, how do I know what's confidential? Are you required to market? Are you required to market separately if it's a trade secret? Those are all things that end up getting negotiated. But it is very typical for at least a clause to say that if they are trade secrets, then the protection goes on indefinitely. Okay. All right, so let's dig in a little bit to some of this ownership by stages. I talked about the client field. So here, the technology related to whatever field the client is in. So if it's this particular client related to personal hygiene formulations, products, packaging, that would be in the client field. Technology related to scents and chemical compositions for scents might belong to the company. This is a really important thing to negotiate. What you don't want are fields that overlap, because if you have that, it's the agreement sort of fails of its own purpose. So you want to make sure you spend a lot of time understanding what's in each field, and it's not just a throwaway. It can't be just a very broad definition. I mean, it's great if it is, but you can't have an overlap. Okay. So we talked about termination in stage 2, where you haven't quite gotten all the way through feasibility. You might handle that by saying that there's a right of first refusal to any of that technology. And so the agreement would have a clause that says that. I know Amber asked a good question. How do you avoid overlap with the relating to definitions? Seems to set us up for failure, especially if the technology is designed to work with other people's products. Yeah, Amber, it's a great question. So you're really talking about what is the best way to allocate ownership, and the doing it by fields way enables you to allocate the intellectual property according to the needs that the party would have for the particular intellectual property, which is why I favor it over just saying anything jointly developed will be jointly owned. But it does raise this challenge. And I think the thing that you have to do is just be very specific about what the technology and the field is. Very often when you are bringing in a partner for a specific kind of development, it's because they have a very specific expertise. And so you might be able to identify that company's expertise very specifically, and then your field might be anything else. That might prevent some overlap. So you might say technology related to company in our example would be formulations and methods of making formulations for providing a scent to a consumer product. And then client field would be anything that is not in company field. That might work as well. But it is a deceptively hard thing to do, but that's one of the challenges when you're dealing with development, is making sure that the intellectual property is allocated the right way. And there is no great answer to making an ironclad agreement. What you do is you try to make the agreements work for as many situations and as best the situations as you can. In stage 3, now you've proven feasibility, but you can't necessarily develop it. The pricing doesn't work, the materials aren't available, or it may not just be a commercial priority for the business anymore. And in that case, in some cases, and again, this is, as you go through an agreement like this, these are examples of how you might allocate the intellectual property, but for each deal, you really have to talk to the business about what is being developed, what are the development stages, and are we allocating this the right way. But in one particular example, where the parties just decide it's no longer strategic importance anymore, you might just say the parties have jointly worked together, they're just going to non-exclusively license each other. If you can go make this work on your end, go ahead. If we can make this work on our end, we can go ahead. We're all not necessarily any worse off. Now, you might allocate this differently depending on which party chose to end the development. But the thing is, at this point, again, the intellectual property interests are probably different than they were if the project ended during stage 2. Finally, the ownership at stage 3. And here, at the completion of a project, the company will grant client a non-exclusive license under company's developed IT to ensure client a competitive source of supply. So here is where you're trying to avoid an exclusivity arrangement. You've done technical work with a company to develop a product, and now you get into commercialization. Now, one of the hiccups at the commercialization stage is they've got you, potentially, you need their intellectual property, you've developed it together, and now they're going to tell you what it's going to cost to enter into a supply agreement. Now, typically, and I'll just scroll back real quickly so don't give everybody, send anybody into a seizure with the quick scrolling, but if you look at stage 3, you will see that in one of the activities are to finalize costs and pricing, and the deliverables are to finalize a commercial framework. That is to make sure that before you get to commercialization, you have an understanding of the terms under which this product will be supplied by the second party, if in fact they're going to be the ones who supply it. Because you don't want to develop it, finish everything, and then them give you the pricing, and you are stuck buying from a party who's now raised the price and now it's no longer commercially available. You also don't want to have a single source of supply typically. A lot of companies will require that their suppliers license competitors for their technology to make sure that they don't sole source. All of the big suppliers, the big CPG firms, will make sure that they are not sole sourcing. So what you want to do is make sure that you are not in a sole source arrangement. Now, this will typically be handled in the commercialization and supply agreement, but you want to ensure that coming out of this stage that there will be a non-exclusive license to be negotiated perhaps at a later time. But you want to ensure that you have a non-exclusive license so that you can go out and get a second source of supply, and especially if commercial availability is questionable, or any of the materials or technology is not available that's necessary to commercialization. So you don't want to go through a development stage and then end up in bed with a party who is going to gouge you, or who might not be able to meet the commitments for the product development that you did. All right. The last part of the development is the statement of work. This is really important because you don't go into development, start sharing confidential information and ideas until this document gets executed. And one of your roles as the in-house counsel is to keep your business people from getting out ahead of the agreements. So as with any statement of work, you need detailed milestones, you need the description of what's being done, you need the acceptance criteria, and if you're going to deviate from the default IP provisions in your development agreement, this is the place that you put that in there. And you want to make sure, again, that you've identified all of the client contributions and all of the potential fees and expenses. I've been successful using this agreement with really, really big companies, with some modifications, but most companies understand the benefit of going through a process like this. They see the benefit of allocating intellectual property this way, of staging the development work so that there's not a premature exchange of confidential information. And I'm hopeful that that this kind of framework and way of thinking about the exchange of confidential information enables everybody here and enables all of you to really think hard about whether or not you want your default non-disclosure agreement to be a mutual NDA. You sign yourself up for significant potential risks if your business folks are signing mutual NDAs without really thinking about what do they need from the other side, and getting confidential information that could stand in the way of them being successful and you owning your own intellectual property, which is, at the end of the day, as an IP lawyer, is the thing that's most important to me. My clients need to own their intellectual property. Okay. I know I've answered a handful of questions. I hope I haven't missed any that have been that were really prescient. There were a lot of comments, so if I didn't get to them, you can throw them into the comments now. I do, encourage everybody to link in with me. I promise that QR code will take you to LinkedIn. It won't. There's no viruses or anything behind there. Go ahead and link in with me if you can. And again, thank you so much to everybody for attending. And I will open this up as soon as I can get my mouse over to my other screen and stop sharing. Open this up for questions for everybody. And I know there was a question up ahead. James Berry asked, won't parties want or need an NDA to even begin negotiating a development agreement as proposed? We don't know enough about our counterparties to know if there is a there to do a deal, need an NDA to get there. Yes, and frequently the parties' joint discussions might need a mutual NDA, but the thing that you need to think about is who is asking for what as the parties start to talk about, are we going to do development with each other? If you are going out to solicit potential partners, you might be disclosing all of the information about the project and about what you need. And all you want to know is, do you have those capabilities? I don't want your solutions yet. I want to know, are you interested? And maybe there you limit the definition of confidential information from, instead of your very specific, your very broad confidential information is anything under the sun that the parties have disclosed, it's confidential, business plan specifications, blah, 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 you've all seen the clause. Perhaps then the confidential information may be limited to the party's interest in a development project. If you are the party receiving, the inquiry, you might say that all you want from the other side is They're details about what the project requirements are, but you don't want any of their ideas, any of their proposals, right? Again, you can, if you're going to do a mutual NDA, you want to keep it limited before you get too far down the road and give each other information that you don't want. And sometimes you can do that by just, avoiding the broad definition of confidential information that most of us are accustomed to, and really making that definition specific to the kind of transaction and discussion that you're having.
Sean Sethna, he's a good friend of mine. He asks the best questions. He always asks killer questions, and he has a great one. Do you want me to read it to you? Do you see it?
Yeah, no, I see it. So, well, now I'm intimidated, because if he's got questions that are that great, I'm not sure I can answer them. If there's a claim by someone under a mutual NDA that someone copied someone else's information, how does that usually play out in a dispute? Does disclosure bear the burden of showing actual copying or use, or is it enough for them to show company had access to the info and they did something similar? Sean, it is a great question. Very often it will depend on two things. It will depend on how is confidential information defined. If there is a definition that requires confidential information to be marked, for example, or if it's not marked, to be followed up with in writing, which, if you are worried about receiving other people's confidential information you might not want, that's a critical clause to include. I've litigated a case where it was clear that what was being disclosed was confidential. Everybody should have known it, but the agreement specifically said confidential information had to be marked, and it was not marked. And the party that was asserting a breach of confidentiality lost. So that's one way of handling it. The other is, there is frequently some negotiation around those exceptions. A very broad exception might be it's not confidential if the other party developed it without reference to the confidential information, or if the party independently developed it. Some clauses say it's not confidential if the party developed it without reference to or access to the confidential information, and that development can be proven with documentary evidence. Those are all potential clauses that are part of an NDA, and depending on whether you are the discloser or the receiver, you are going to want to pay very close attention, because those clauses will dictate what is going to happen and how proof is going to play out at trial.
And I have a question from James today. He asked this before. I don't know if you got to it, but can language from the development agreement be integrated into a Form NDA?
It can, but you're at that point you're kind of going backwards. The development agreement is really, there's a lot going on there, and it's probably not appropriate for the NDA. On the other hand, if you've got a very broad mutual NDA, you can incorporate that and just keep it going as part of the joint development agreement. You may or may not want to do that. Again, if you're just having a non-disclosure agreement to talk about a project, what you might do then, once you engage in the project, is to terminate that NDA and replace it by whatever confidentiality clauses are in the operative agreement.
I think the next question, not to intimidate you, hopefully it relates to feedback and ownership of feedback. There's a lot of feedback anxiety, I guess you can say. I'll read this question, and I think it encapsulates all the other questions. In contracting for ownership of feedback, I've heard that it is not possible to own an idea. Is that true? And if so, is the goal to contract for the use of feedback for the purpose to profit, et cetera? Or should I aim for a license tantamount to ownership?
Yeah, Olivia, that's a great question. And boy, feedback and improvements licenses are a whole nother topic, and I'll talk to Shay about maybe putting on that presentation another time. I will tell you this about feedback. Yeah, you can own an idea. Trade secrets are very frequently ideas, and they might be the most valuable intellectual property that you have. And so if feedback rises to the level of a trade secret, it's absolutely protectable. But even if it doesn't rise to the level of a trade secret, if feedback is something that is confidential, that gives you a technical advantage because you know now how that party would envision using your technology or where they're going in the future by virtue of their feedback, you might end up in a real sticky situation, because you then don't do a business deal with them, or even if you do, Here, let me put it this way. Let's say you develop plastic bottles, uh, and you're going to pitch Clorox to put their bleach in plastic bottles, and you've got really great plastic bottle technology, and you're not just selling to Clorox, you're selling to P&G for Tide detergent, and you're selling to Heinz for big jugs of ketchup, right? And Clorox says to you, "I love your bottle, but I want to thread the cap on a different way because our customers view the cap coming on and off as a real problem." All right. Well, let's say now you're aware that the cap is a big problem in the industry. You were working on that. Now, you may not have come up with what Clorox told you they wanted to do, but you probably would have. You've got developers who do that for a living, or you might already have it. Now, what do you do when you go to Procter and Gamble or Kraft, right, and you want to disclose the new cap disclosure that you just came up with that Clorox told you about 3 months ago? And now Procter and Gamble wants to buy that bottle with that closure, and you go, "Oh crap, I had an NDA with Clorox. They told me that under an NDA. I'm not sure I can prove I didn't get it from them. I best not disclose that closure to Kraft or to Heinz, Kraft Heinz, or to Procter and Gamble." And now you've really limited your development, and it's all because you agreed to keep feedback confidential. So it is really important that again, that's one of the downsides of the mutual NDA, and getting into an agreement or a situation where under a mutual NDA there's a free exchange of ideas where you don't want it to happen. So hope that answered that question a little bit.
I think the chat is a little bogged down. I have some questions that I picked out. Can you talk about, well, so the question is, how many cases in the US involve litigation for breach of an NDA in relation to IP or joint development agreements? And I think it would be interesting to just talk about, what's happening in the litigation world around NDAs. My experience, I feel like they never get litigated, but I'm sure across the country they do. So I would be interested to hear about that.
Yeah, they do get litigated. The problem is when they get litigated, they're very frequently big litigations because the cost of litigating over a breach of a non-disclosure, some sort of breach of confidentiality that's not all that serious. It's maybe questionable. Maybe the confidentiality was sort of questionable. Probably didn't keep it as a trade secret. You're overreaching. That's an expensive undertaking. The big ones occur when we call the head start, right? And that's really, one of the issues with a mutual non-disclosure agreement or receiving somebody's confidential information is the claim that you got to market sooner than you otherwise would have because of the confidential information that we gave you. Sure, you might have developed this innovation on your own, but you wouldn't have gone there if not for us. And that 6 months brought you certain exclusivity, certain amount of profits. Right now you're disgorging profits for that head start that you had, right? And the value of that head start can be enormous. There was, I think Monsanto had a case around litigating a non-disclosure agreement where the head start was in the 7 or 8 figures because a party had received non-disclosure information that was confidential and began their development using that information before the material was public. So this could be, for example, receiving information that is subject to a pending patent application that's not published yet. And now you start working on it, and you were 18 months ahead of everybody else who didn't know about it until the patent application was published. That 18 months of head start can be an enormous amount of money. And that head start litigation is pretty frequent. When that head start well, I don't know if it's frequent. I'll say when that Head Start litigation happens, it's usually for big money.
The presentation recording, it's going to be available in like about a week to 10 days. We like edit the presentation. It's not CLE eligible, so we take out all the interruptions due to CLE and other like in time notification. So it will be recorded, it will be available, but not for a bit. So keep that in mind. I see a couple of more questions came in. Do you want to take Michael's?
Yeah, the liquidated damages question. Boy, Michael, that's a really hard one. I haven't seen a lot of liquidated damages clauses in confidentiality agreements. Liquidated damages is, again, it's another one of those. It's its own topic. The problem with liquidated damages clauses, at least in my view, and I'm just thinking about it out loud, is it can't be a penalty, right? It's got to be a reasonable compensation. And I think at the time that you develop a non-disclosure agreement and put it together, it's really hard to value what the confidential information would be. And so it's hard to create a liquidated damage that would be as large as the worst kind of disclosure would be, without it looking like a penalty. And I think it's much more likely that a non-disclosure agreement is going to be enforced through injunctive relief. And then and the other thing is, if you have a liquidated damages clause, I would think that suggests that you can't get injunctive relief because you can quantify the amount of damages. In other words, the harm's not irreparable. So I would think might not want to have a liquidated damages clause in an NDA where you might want to run into court with a preliminary injunction or TRO. But that's just off the top of my head, my thoughts on that.
So we'll do two questions. So how about the best practice for the governing law provision in NDAs? How do you handle that? Do you think it like usually sides agree, or
usually sides agree. If they don't agree, most people just say Delaware, because Delaware is usually a pretty neutral law. All right, so I'm trying to decipher Kimberly's question. So entity 1 has a contract with entity 2, or entity 2 is to provide a deliverable, entity 1 for a system, entity 1 wants to share with entity 3 that testing data so they can build a system to interface with what entity 2 built. For testing data, Bismarck confidential, is entity 1 prohibited, or can entity wait? Well, Kimberly, I think I'll give you the lawyer answer I haven't used yet, miraculously, which is it depends. This is one of those situations where knowing what you are receiving and what you want to do is important before you sign the agreement. If you know you're getting testing data or anything from a party that you then want to shop around or use with another party, you had best make sure the confidentiality agreement allows you to do that, because that's exactly the kind of thing that we're talking about. The business signs a mutual NDA, doesn't really understand what it does, and then finds out that they can't go off and do what they wanted to do with it. That was the example I gave early on about the procurement people wanting to get pricing on source of supply so they could shop it around, and didn't understand that that's exactly what the supplier didn't want them to be able to do.
But one more question.
Sure.
Indemnification clauses in NDAs. That's an interesting one. I always used to strike it, but what are your thoughts on that?
Again, it depends on which side you're on, right? If it's a one-way NDA and you're the disclosure, sure, right? If it's a mutual NDA, it depends on your risk profile and what's being exchanged and whether or not you think you want to be on the hook for that. I guess I look at it this way. In NDA, if there is a breach of an NDA and it's a true kind of trade secret breach, you're not limited to consequential damages like a sale of goods. And so I don't know that what indemnification clause might get you, except maybe an explicit cause of action that has a chilling effect, again, maybe on the recipient from disclosing. It's probably one of those clauses that you're just going to end up arguing over and either make mutual or just decide to delete and move on.
All right. One more question, because I'm a sucker. Is there a jurisdiction that's particularly good to having an NDA or a confidentiality agreement, or I guess It depends.
That's a really good question. Uh, I I don't know that there's necessarily a jurisdiction that is better from an NDA perspective, but what you would want to consider is is if there are state law, anything unique in state law about litigating trade secret disputes, um, that that you don't fall into a jurisdiction that's going to apply some sort of trade secret law that is more or less onerous than you want it to be. So that's a very broad answer to a very broad question.
All right. Well, okay. So, first of all, again, thank you, Dan, for delivering such a fantastic presentation, for sharing your vast experience and insights with the In-House Connect audience. We tremendously appreciate it.